But yes, I'm broadcasting from my lair at work.
Good deal. Good deal. We're live now.
Oh, well, alrighty. So I guess that means I should, sit down and be professional for a while, right?
Well, you're professional all the time, Derek. So, but no, you can move around. So for those of you who are just joining us, we will, as become customary, give everyone about 5 minutes to join before getting started. So that means that we'll be getting started about 2:35. If anybody has any questions or know of any friends who are saying that they can't join, please have them send me an email, um, and we'll get started at 2:35. Hello, everyone. We will be starting at 2:35. We're just waiting for people to come on in the room, and we'll be getting started shortly. Thank you all. Okay, Mr. Bisig, if you want to come on screen. Thank you
Hello.
all for joining us for legal writing for our end of the year CLE. We have Mr. Derek Bisig here to present to you all. Mr. Bisig will give you a brief bio of himself and then launch into the presentation. Mr. Bisig, take it away.
Well, hello, everybody. My name is Derek Bisig. I am a practitioner over in the vast metropolis of Jennings, Louisiana. I have my own practice out here where I practice in family law, criminal defense, and I do municipal practice as the in-house counsel for the city of Jennings. So today we're going to go over legal writing, everybody's favorite subject in law school. I know it was one of mine. Usually most people just thought, let's just survive it to get on to the next thing. Whenever Marla first asked me to do this, of course, I was trepidatious. And then I thought, sure, yeah, I'll give it a whirl. And I started thinking about what are we going to do with legal writing? Like, am I going to literally lecture for an hour and 15 minutes on comma usage? I don't know about you, but I would be clicking the X at the top of the screen pretty quickly. So I started thinking of some other things that are beyond what we normally think of in legal writing, such as motions and memos. But not to worry, we are going to get on to the motions and memos as well. Let's see here. There we go. We're going to get to them, so do not fear, but we're going to go over some other stuff first. So when I sat down, my first thoughts on legal writing were, number one, why did I draw the short stick out of all the fun things to present on? Number two, is it too late for me to contract COVID and get a 14-day stay out of this? And number three, I have not written anything academic since law school at all. But then I actually started thinking about it. And if you start thinking about it too, we legal write all the time as lawyers. We're wordsmiths. We can turn a child molester into a misunderstood babysitter just by presenting the facts in a proper method. So we write every day. We write from the most formal all the way to very informal, things such as texting. We text judges and lawyers and clients all the time, though I don't like texting with clients because that will always come back to bite you. But we text each other all the time. In today's society, we are texters. We're more instant gratification. We get through stuff fast. And we tend to forget that we are talking to our judges, we're talking to our colleagues, and we're talking to our clients and not our buddies. So what you're going to want to do in these things is, sorry about that, guys, is that we also write emails with one another. We send letters out to clients and to judges. And if we really, really, really have to, we'll draft and file a motion or a memo with the court. So legal texting, let's start with this. And now that I'm back on track, texting in the legal world, how does this work for us? We want to avoid using texting shorthand. And you know what I'm talking about, where you have to basically use a cipher to understand what's going on. You want to avoid doing that. And the reason why is because you can confuse the reader. Not everyone is used to the texting vernacular that everyone else is. You want to make sure that you are also not writing or texting in the way that you speak. You want to keep it a little bit more formalistic, even though it's a form of informal writing. Another reason why you want to avoid texting shorthand is because you lose credibility with the reader. And I talked to one of the judges about this, and he seriously received this text message from an attorney asking him or requesting rehab for his client. Now, with us being in a smaller district, we have a little bit more of an intimate relationship with our judge. I'm in a one judge district. I don't think anything like this would ever happen in a jurisdiction like New Orleans or Baton Rouge. Who knows? But he seriously got this text message saying, "What's up, Judge? Why you gonna hate on my client? He seriously needs the rehabs." Needless to say, this guy did not get his client into rehab. The next thing, you want to use proper punctuation. Sorry, guys. You want to use proper punctuation and capitalization whenever you're doing this. Nothing is worse when looking at a screen, just one big old block, and there's nothing to break it up. It's hard to understand and it's hard to consume as the reader. It adds clarity to your writing whenever you use proper punctuation and capitalization. There is a small example of this coming up, which is, it creates the difference between "let's eat grandpa" and "let's eat grandpa." Punctuation can save lives. One, you're going to make a meal of grandfather. The next, you're going to have a sumptuous pot roast with grandpa. The last and most important thing about texting in the legal world is you will not look like a moron when your opposing counsel uses your text message as an exhibit or when a client attaches them to a complaint with the disciplinary counsel. As I said before, these things have a tendency to creep back up on you, and you want to make sure that you're always putting forth the most professional demeanor that you can, even through texting. Next is one of the things that we all do all the time is email in the real world, in the legal world, I'm sorry. Whenever we're emailing, we tend to just shoot off short messages just like we do in texting. Here, you want to go a little bit more formalistic than the rest. So you need to choose one, a professional email handle. Like I use derekbisig@gmail.com or derek@bisiglaw.com. This presents more of a professional outlook to the world, and it puts people in the mindset that they are dealing with a professional. You want to avoid emails such as this: Studmuffin72 and Pink-a-Daisy. Now, I wish I could tell you that I was making these names up, but these were emails actually used by attorneys here in this district. And no, they're not no longer employed with the agencies that they were. And yeah, I did change it to both at Yahoo because I didn't want you guys to shoot them off emails telling them that they're absolutely crazy. So, remember, be kind, rewind, don't bother the animals. Okay, you would want to begin your email just like any other letter. Okay, so when you open it up, you want to say, "Dear John," here, "Dearest Grandmama." Now, you're going to continue to use proper punctuation and capitalization. Contractions in emails are okay. So what's a contraction? Can't, won't, shouldn't, anything where we do the apostrophe or the comma to the top with at the end, that's what you're going to use the contractions for. You don't really want to use these in your most formalistic writing. You want to use these in your informal writing because you do want to kind of keep it conversational, even though we're trying to be professional with our clients and whomever else we're emailing. So you would go to put in your body, "Dearest Grandmama, it is my sincerest wish that we no longer need to churn our own butter and bake bread." Apparently, when I was writing this, I had just finished watching an episode of Downton Abbey, and I was just going with it. Apparently, I live with the downstairs crew and not with the family upstairs. Then finally, you're going to want to end your email with a closing and a proper signature. So just like you would, you have your email and you put "Much love, Derek," because I'm writing to a family member and not a client. Now, why do I give out some of these crazy examples? It's because just like in the real world, the crazier the example you give, the more likely you are to remember it. Just like that crazy case we read in law school about Durian, the gas ball man who someone happened to not take their seizure medicine and had a seizure, and then there's an explosion and a tractor goes loose, and then someone falls into a pot of oil and turns into a gas ball. I'll never forget that with learning limitation of liability and torts. Same thing with these examples. I know they're a little off, but just bear with me. And then finally, as a lawyer, in emails, you want to make sure that you're also protecting the confidentiality of your communications. So it's pretty formal, or pretty, not formal, pretty expected to have like a confidentiality statement at the end of your email. And you wanted to let them know that, this is confidential, and should they happen to intercede this, just go ahead and like give you a heads up. So at least that way, that it was put out there without your knowing. Now, a tip that I received from another lawyer, which it has come in fairly handy with me with email, is that we have a tendency to go fast, because just like we were talking with texting, we want to go fast. We want instant gratification. We want to move on to the next case, because we're busy practitioners in the real world. So what you do is I get an email in from lawyer A, and I read it, and then I send it to my client, Mr. Doe. Well, Mr. Doe gets lawyer A's email, and he doesn't understand everything in the email because there's some jargon, there's some legalese, maybe lawyer A is being a little snarky in his email, and I send that directly to the client. What you would want to do in today's world is you want to take that email, pull out the most important information and any attachments that come along with it, and then restructure a full new email. So that way the client sees it through your filter and not the filter of another attorney, because you want your client to understand what is going on. And we're going to talk a little bit later about knowing your reader and how to present things for your reader. And guys, at any time, if you are just bored or you need me to stop talking, you can just raise your hand, or you can send in a question and I'll answer that as we go. So now we're coming up to letters in the legal world. So these are our letters that we send out to adversaries. These are letters that we send to our client. And these are letters that we would send out to as a demand to go ahead and, say, like, I need you to act right and pull your life together, or we're going to go ahead and file suit against you. So the first thing when writing a letter is that you want to design a professional looking letterhead. Even though I have only been in practice for the large amount of time of 2 years, I have seen some very interesting choices that lawyers make whenever they are designing their letterhead. I've seen some with puppies and kittens. I've seen some in wild fonts. I've seen some that, just didn't really convey that this is, a professional that I'm dealing with here. So you want to avoid fancy fonts. You want to pick something that is easy to read, one that your readers or those with, let's say, more experienced eyes can look at, and the font doesn't make their eyes or their vision blur as they're trying to read it. Just like in emails, you want to use a greeting, you want to construct the body, and you want to end with a closing signature. Contractions may or may not be used. If you've noticed, we're going from the least formal of writing, texting, emails, and we're moving our way up the scale to more formal writing. Now, you want to avoid confusing language, wordy sentences, or legalese. Why do we do this? Because most letters are going out to lay people. They didn't spend the 872 years in college like we did, and then the following 3 years in law school, and then sit through the torturous bar exam like we did, just so they can, sit down and open a practice and hang a shingle or join into the legal world. These are going out to some people who may literally only have a third grade education, and you want them to understand you. You don't want them to go to someone else and have it explain it to them. You want your words to convey exactly what you want. Now, let's take, we're going to use an example that I use with the city of Jennings, where I work as in-house counsel. And what was going on here, to set the stage for you, was there is a new tendency in litigation for practitioners to look at a municipality's social media. So that's their Instagrams, their Facebooks, their Twitter accounts. And all of these things are considered public records. So you have to preserve a public record, one, for archiving purposes, and then two, just in case for litigation, for discovery purposes, because these are public records now. So there is a program out there that will actually come in and archive all of the social media accounts, and they will trap these things or capture these public records and present them should there ever be a discovery request. So we got all the entities or the departments to sign up with their social media with this account. And then there was one lone holdout, and I bet you guys can guess who it is, any of you guys who practice municipality law, that yes, it was the city police who did not want to link up. And when saying they didn't want to link up, this is the email or the letter that I received from the detective. He sends, Derek, a succinct update in regards to our Facebook page. Evidently, our Facebook account created for the purpose of archive was removed, deleted by Facebook. Due to this, it requires another archive with a new account. After a deliberation, Chief and I have carefully considered both the advantages of acquiring pertinent information through our page as well as the ability to disseminate relevant information to the community. However, due to the numerous steps and maintenance of the page in conjunction with limited time away from casework, we have reached a decision to reform the Jennings Police Department Facebook page to inactive. All activity on the page, such as posts and updates, will be suspended. The page will no longer occupy any active admins or editors. And we appreciate the efforts afforded to the page in attempt of protecting the department and city. However, we have deemed the page to be dispensable. Wow, that's a mouthful. So I didn't know what to do with this when I first got it. First off, my first thought was this English? I think my nervous system shut down and rebooted. I had to read it several times to actually parse this out. And then I finally figured out where he was going with this. He could have said all of that in one sentence. Derek, the city police is closing and deleting our Facebook page. Thank you. This is what we're talking about when we're talking about wordy sentences and convoluted sentences. As you could see, there was a lot of commas missing, a lot of sentence breaks missing, not to go into all of the legal writing nerd stuff right now. This lecture is more geared toward how we should present ourselves and some tips as practitioners, and not me teaching you guys how to use a comma, because let's face it, we could all buy a dictionary and do that. And then of course, nothing is more fun than listening to someone read off their PowerPoint presentation while, you're just trying to collect your CLE credit. But we're going to get through it together, guys, I promise. So this is what we're talking about with things being wordy and with things being convoluted. You don't want to do things such as this. I've always lived by this right here, is that if you can't explain it simply, you don't understand it well enough. And this could also be kind of transferred into some things that we hear with lawyers whenever we're reading their work, or when someone is reading your work, that if you go into these long, drawn out explanations, one, you don't understand it, because you should be able to get this on, as Professor Reed used to say, a bumper sticker of the law. You should be able to sum this up in 2 or 3 sentences. 2, you lose the reader. The reader just gets bored and travels off. Second, and I've seen this in practice too, that clients will pretend to understand you because they don't want to appear uneducated. for some reason, and I don't know why, that there are a pretty large majority of clients out in this area where they're more blue collar workers and they haven't really had the formal education that I've been privileged to have. And that they will, yes, I understand. And they'll walk out and they won't do anything. Yes, Miss Helena, let me see if I can get over to how do I get this? I can see you raise your hand. I just don't know how to check it. Go ahead, Helena.
I put her on the screen so she can talk.
Okay, I'm trying to get her unmuted, and apparently I don't know how to do it. There we go.
Yeah.
Is that you, Helena?
Yes, that's me.
Okay.
How you doing?
I'm good. How are you?
I'm doing well. Thank you.
Thank you for saving me from rambling on. So yes, ma'am.
What did I do? Did I press something I shouldn't have?
Oh, yeah, you raised your hand as though you had a question.
Oh my gosh, I'm so sorry. I think I was moving my phone and I must have done that on accident. I apologize.
No, you're fine. You're fine. Gave me a second to get a breath and to get some water.
Okay, well, you're welcome.
Thank you. All right. Thank you, Miss Helena. So a lot of, like I was saying, a lot of clients, they don't want to appear uneducated because they feel as though, we're lawyers and they don't want to feel like they're beneath us. The next thing, let's see if I can get back on is that we have to remember too, as lawyers, and we tend to forget because most of this stuff is every day for us, is that most people come to see a lawyer when their life is falling apart. They're getting a divorce. They've just been arrested. There was a death in the family and they need you to do their succession. They were just in a horrific car accident. The last thing that they need to hear from us is a ton of legal words and a ton of convoluted and complex stuff. They just, one, they need someone to listen. And two, they need someone to speak for them and to act for them. And one of the strongest ways that you can do this as a lawyer, besides your voice in court, is through your writing. So personally, I like to take the Star Trek approach. Yes, if you haven't guessed by my slides, I am a super nerd and I love it. What's called the Star Trek approach? Derek, this is supposed to be about legal writing. Where are you going with this? Okay, hold on, guys. I'm gonna land the plane in just a second. So what this is, the Star Trek approach, is a method for connecting with people through your speech and your writing. What it means is that you come in and you use the complex legal terminology with them, same thing in your writing, and then you follow up with a familiar example, like this conversation between me and one of my clients. Opposing counsel filed a lis pendens exception in response to a plaintiff filing suits. Co-counsel filed a lis pendens exception in response to a plaintiff filing suit in both federal and state district courts. They had the same causes of action, same remedy sought, same parties. So we all know what's going on here, lis pendens. Yeah, we're going to ask someone to take a break. Well, a client doesn't really know that. First thing out of the client here, it was the mayor's mouth, was what's a lis pendens exception? So using the Star Trek approach, you explain a lis pendens exception is a legal concept where two things are trying to be heard at the same time, and you're going to try to stop the duplication of effort and have one go before the other. Okay, that's kind of getting it. He kind of understood. So then I use an example with his family. In other words, imagine if your son wants a piece of candy and he comes to you and you say no. So your child, being the smart little clever boy he is, goes to your wife, Katie, and says, hey, Mom, can I get a piece of candy? And Katie says yes without ever hearing one another. Just like with children and parents, a lis pendens exception stops a plaintiff from playing one court against the other. Whenever I use this example like this, and this was all done through text, the mayor got it. He understood what was going on and he knew where we were going from here and what was expected out of him in that suit. So now we're coming up to the big stuff. We're coming to the back end of this, and apparently I'm going super fast, faster than I practiced. We're going to go into petitions, motions, and rules. Oh my. So petitions, rules, and motions, we all know there's three parts to them. So we have the part where we lay down the factual basis, the facts, we pray for it, and then we have it ordered. So the first thing in the beginning section is that we lay the case out. We do it in short number paragraphs, and we allege all the good stuff, which is like who the party is, who the defendant is, why the venue's good, why the jurisdiction's good. Please don't throw me out of court with an exception, you know, those things. And the next, we pray for the outcomes, where at the end, we pray that all just and equitable relief be granted to our client. And this is the part of the program where we're asking the court to give us some things. Then finally, the court orders that a date should be happen to, you know, rule to show cause, why we should not grant sole custody to client Y. Okay, and we do all of this stuff for our clients with that. Now, big note, do not forget to sign before filing. The clerk does not like it. And two, the other attorney who practiced in this office with me found out the hard way that the clerks really don't like it and they make fun of you. Now, going to give you some advice now. So all students who are currently in law school, you're going to want to turn this portion of the lecture off. It's just like in the Lego movie where everything is awesome. In real world practice, plagiarism is awesome. But just like lawyers with our trust accounts, how we don't steal from our clients, we convert. Lawyers do not plagiarize. We borrow and learn from those who come before us. You know, we're busy. We got lives, we got things to do, and the courts do not expect you to reinvent the wheel. So if there is a form or if there's a memo out there or anything that you can use to help yourself in life, check them out. LexisNexis and Westlaw both have built huge databases for these motions for you and memos for you. But the last tip that I do have in this is that whenever you are borrowing, that you should always take a moment just to check their laws that they quote and their cases that they cite to. And the reason for this is that you just want to make sure that something hasn't been repealed from the code or that that case hasn't been recently overturned. So finally, the last thing that we're going to cover today, I went a lot faster than I thought. The last thing that we are going to cover today is memorandums. So this is going to the more formal end of the spectrum of legal writing. And this is where you are going to set out your case and your version of the law for the judge to help make a decision based off of a memo you filed. You know, this is where you really get your words out and you really speak your client's truth. Now, we're getting to the top of the pile for you guys. So we're almost there. We're in the final stretch. So memos, everybody's favorite. It's like having homework all over again. But are they torture or are they legal weapons? Dependent upon your judge. Now, with tips, pick a format you like and stick to it. You don't have to reinvent the wheel every time you sit down to a format. My favorite format is the one that was taught to me in law school by Professor Sparks, and I think it was taught to her by Professor James. And it's a great format. It just starts out with the facts and then the questions. So you're really breaking down the issues of what's going on in the case. Then you go into the answers that you want the court to arrive at, and then you do your law section. And we're going to go through this in just a second. Next, know your local rules of court. This is more important in some jurisdictions than others. You can find the local rules of court at the Louisiana Supreme Court website, and you can look under the district court rules. So the local rules of court are, let's say in the 19th district, they prefer to have everything in 14.5. And then in the 31st district, they want everything on letter instead of legal. You know, it's the court's idiosyncrasies of how they want it. Now, some jurisdictions take these things extremely seriously. Excuse me. take these things extremely seriously. Some jurisdictions will even throw out your suit if the local rules are not followed, and that can be dangerous with some prescription deadlines. You don't want your suit to be thrown out for form whenever you've missed the deadline. Now, if you're in my court, unfortunately, the local rules, just like in the Pirates of the Caribbean with the Pirates Code, are a little bit more of a guideline. Our judge kind of lets everything slide with his local rules, and that's okay. So, more tips for memos. You want to use short sentences. Going back to earlier's example, is that you saw it was wordy and it was convoluted and you couldn't really see where they were going and they were using big words improperly, and so then you're caught up on that, or at least I was. So you want to use short sentences. Short sentences convey powerful messages. If a sentence runs on the paper for more than 3 typed lines, consider breaking it up. Another thing is that just like with long sentences, long paragraphs will also lose the reader. You want to break things up into smaller paragraphs because they're more easily digested. You can handle things in small quantities better than you can in larger quantities. And it's just kind of like that old joke of like, how do you eat an elephant? One bite at a time. Same thing. How do you digest a legal memo? Is you do it 1 sentence at a time. So if things are scrunched down into small bite-size portions to understand, then you get your message across more effectively. The next thing is that you want to start in your law section, you want to use definitive statements. Start with a strong definitive statement, such as the defendant's peremptory exception for no cause of action should be dismissed. That way the judge can go down and he sees, oh, this is where we're talking about this portion of the program, and then he can go down and start reading your law and your reasoning behind the law of why this exception should be tossed out. You want to use many headings and subheadings. Why do we want to use many headings and subheadings is because exactly what we were talking about before. The judge can zero in on the section that he has questions about based off of your memo. A lot of times the judge doesn't read exactly everything in your memo. If they already agree that the exception should be tossed out, then they'll just skip that section entirely and move on. You want to think little pieces are easier to read. Remember the book that came out, the Da Vinci Code, about how everybody thought that they were reading so fast because the chapters were only like 2.5 pages long. Same premise, just a different filing or different publication. You want to be able to give your reader the ability to go through their memo and get where they want to be as fast as possible. So, my suggestion for writing a memo is to start with the law and the argument section first. Why do we start there? Because usually, I don't know about you, but when I sit down, starting is the hardest portion of this program because I'll sit down and I'll look at it and I'll look at it and I'll look at it and I can't figure out where I'm going on. But I've already done all the research, so I know where I want to end up. I just don't know how to start. So for me, it works best to starting with the law and the argument section because that way I start really focusing in on what points I'm trying to make. Now, we all know in Louisiana, we are a civil law jurisdiction, so therefore we need to start with the code first. Same thing, once you make your point at the beginning, you say the defendant's exception for no cause of action should be dismissed, then you want to find a code that supports you. Even if you have to start with just the basic code for what a peremptory exception is. You want to start with the code first because that is the strongest level of law in Louisiana. Then you go find a case to support your position. Now, whenever you're looking through cases, make sure that you do not deliberately hide things that are contradictory toward your case. And I just kind of see it every night whenever my cat, who adopted us in April, when she goes to clean up her messes in her box, that she will look at us and then slowly drag her paw to hide it. I kind of think of it the same thing whenever we're trying to hide case law that we don't want the judge to know about or the opposing side. Don't try to hide it. Don't be a cat in their litter box. What you want to do is that you want to face that case head on in your memo, and you want to explain that, no, this is different from the case where the guy sold 1,500 ecstasy pills to the undercover cop, because my guy, even though he sold 1,500 ecstasy pills to the undercover cop, the cop also sat down and partook in the pills with him, and therefore things are bad here. So you want to distinguish it, not hide it. The other thing is that opposing counsel will find it usually, and they will embarrass you in front of court. The next is, do not misquote the case you are citing, because nothing feels better than checking the opposing counsel sites whenever they give you their memo, because you go through it and it takes about 5 minutes to just read their stuff and their cases real quick. And you could say, actually, Your Honor, opposing counsel citation to Ham v. Wolf here, when fully read and not cherry picked, says that, the big bad wolf actually was held liable for biting Porky Pig, and not that he was, the limitation of liability was cut off. So you don't ever want to cherry pick out of your law. You want to actually pick law that the full sentence says what you're trying to say, and not just a portion of it. And you'd be surprised the amount of practitioners that do this, or the amount of practitioners who, when they're writing their memos, don't quote to any law at all. They'll just, I've seen it in the public defender office, where there are some of my colleagues who have filed motions to suppress, and you read their motion because you're trying to dig through building your own motion practice, and you're reading their memorandum attached, and it basically just says stop bad. And you're like, oh, okay, but why is the stop bad? Like, where's your basis? Give me something. You want to always have something to base what you're saying off of. Give yourself some authority. And the last tip that I have for this is also, when you're looking for cases, find cases in your circuit first. So if you can't find anything in your circuit, and I know this is getting more into legal research than into legal writing, but it links up with one another. You want to find something in your, sorry, I was reading that chat bubble. You want to find something in your jurisdiction first, because that pretty much tells you where the court is going to rule, or where the court should rule. We all know how that goes. So currently I'm in the Third Circuit, and so I need to find Third Circuit cases first, because it's all great that there's this absolutely wonderful case out of the First Circuit that's saying exactly what I want, but if the Third Circuit is contradictory, then that's going to be a problem. So I have to choose the Third Circuit case, distinguish my case, and then show the judge that there is some persuasive authority out there that I can use to buttress my argument. Now, the next tip that I have is know your judge. There's some just like knowing your reader. So you got to know your judge, and you got to know your reader. Why is it important to know your reader? Well, let me give you an example from law school. I had wrote a little missive for the law review, something to keep me entertained while I was there, so I could get my advanced legal writing credit. And I'd let a professor read my article because I wanted to know their opinion, because it was slightly in their frame of reference. And this professor read it on their iPad, and we had talked, and I kept getting things, well, you didn't say, you haven't talked about this, you haven't done that. And I would show them, it's right there 2 sentences later if you kept reading. And it made me think, aha. So this person reads quickly and they don't see everything. And it was the only final in law school that I ever wrote where like a pre-law student, where I literally wrote issue, the issue is this. Rule, the IRAC method, where I really wrote it out. And the reason is because I knew that this grader does not pay attention while they're reading. So I really needed to grab their attention. Now, of course, when I went to review, there was all kinds of things on there like elementary writing and juvenile presentation, but I got their attention, and I made a B- in the class, I think. Not that I need to brag about that, but it's just a story that you need to know your judge and you need to know your reader. Same thing we were talking before with keeping things simple and keeping things easy to understand, is that if you know your judge does not read things, then you probably don't want to put as much effort or minutia, not I want to say effort, minutia into your memo. You want to keep broad strokes to keep the judge's attention and know that you're going to have to buttress more on your argument. Same thing with the reader, that if you know your client is of modest education, you're going to want to structure your letters and your communications to your client in an easy to understand manner as opposed to an academic manner. Now, my judge reads every memo of every sentence of everything that is handed to him, and he does this because he likes you to lead him down the path. If you can give him a strong legal argument and he agrees with you, he will go with you and he will basically cite exactly what you've written to him. Other judges, they don't read anything that goes into their courtroom. My biggest failing is that when I come across a judge that does not read the memos, is not starting off my argument with, well, as I wrote in my memo, Judge, don't follow my advice. Okay. So we've started with the law and argument section. Next, we're going to move on to the conclusion. Write your conclusion first. And a lot of prosecutors will tell you whenever they're practicing and prepping for trial, they start with their closing statement instead of their opening statement. Same thing with your memo. If you start with your law and then you get all of your conclusions in there, and then you get into your conclusion section, you already know where you're going and how to land this plane because you've done it all in the law and argument section. Now, let's go to your factual background section. Why do we want to use the factual background section? And I had someone call it this while I was in law school, and it's always stuck with me. It's the fact graveyard. There are some people or some practitioners that whenever you read their stuff, they're going on and on and on and on about this person's pink poodle that they just had died, and the case is about a car wreck. We don't need to talk about the pink poodle unless the poodle was in the road somehow. We don't need to talk about how their pink poodle was at home in the kennel. That's kind of where we're going with this fact graveyard thing. It's just where facts come to die and they're just left there for no apparent reason. That's another reason why I suggest to do your fact portion last, is because you are actually more focused after you do your law section. You're more focused because you've already picked out, while you were writing your law, you're picking out your law, you're picking out your case, and you're saying how the current case is exactly like it or is distinguished from it. So you know exactly what laws and everything you've picked and what facts you needed to pick. So then you could just basically take those facts and then put them up into your factual background section at the top of the memo. Now, the final step that you need to do in this is to proofread, and do not rely just on Microsoft Word alone. Microsoft Word will sell you down the river. The reason why is because spell check will say, will not point out a trail or a statute. They will, those are right words, and we're looking for words like trial and statute. So you want to make sure that everything is good to go. And proofreading is extremely important to the process, because then you start editing yourself and you can start shortening your sentences and making them more concise and making them more tight. And one of the most horrific stories that I've heard at a law school when I was there was one of my colleagues stated that they never proofread anything. They just type it out, and whatever went down in the first draft, if they weren't smart enough to grab it on the first round, then so be it, let the chips fall where they may. And all I thought was, wow, you are leaving a lot of points on the table. You need to, same thing with your writing whenever you're presenting to the court, is that you want to practice, you want to proofread it, you want to go through it a bunch of times, you want to edit a bunch of times, and still, without fail, there will always be a proofreading mistake that you'll catch after you file it, whenever it's in the public record. Fun tip for that, since I am in such a small parish, my younger baby sister works for the clerk of court. So not only do I file my mistakes in the public record, she gets to call me and tell me how many mistakes I've made, which that's great for the ego. So circling back to the, if you can't explain it simply motto, you don't understand it well enough, your most important goal with all of this is just to make sure that your writing conveys a clear, consistent message. You don't want others guessing what your writing means. You want to explain what your writing means whenever you say it. Your works should stand on its own, and you should not need anyone to filter it through for you. Yet again, you want to tighten up your sentences and take out all unnecessary words. And just remember, there's a quote out there from Shakespeare that brevity is the soul of wit. Lawyers are infamous for taking 50 words to say what they could say in 10. I'm bad with it myself. That's why I have to edit myself so much. And same thing with presenting. So guys, this is my last slide here. Just remember that judges and interns prefer if you can get to your point quickly and succinctly, because their homework pile is just as large as yours. So with that, I am available for any questions, or if we're all ready just to get our CLE credit and get out of here, we are good with that too.
Does anyone have any questions for Mr. Bisig? It was a wonderful presentation.
Oh, well, thank you.
Want to take some time to